Welcome to the Grow Your Business and Grow Your Wealth podcast with Gary Helt. Gary is an expert in helping business owners put together a plan that will provide a better future for their businesses, themselves, and their families. On the podcast, Gary interviews other professionals who share his vision, and together they share secrets and strategies any business owner can use to build a better financial foundation for your business and your life.
Welcome back to the podcast. Today, my guest is Geoffrey Kunkler with Carlile Patchen Murphy LLP. He joined there in 2014 and became a partner in 2018. And his practice primarily centers around estate planning for individuals and business. Good morning. How are you?
Doing good. Thanks for having me. Excited to be here and share some wisdom with your listeners.
Great. Appreciate it. So what made you pursue a career in law?
Yeah, I sort of always knew I wanted to be an attorney. Dating at least back to high school, I did speech and debate actually, and enjoyed the argumentative side of things. Sort of always dreamed I'd be in the courtroom. I don't know if that's from watching A Few Good Men or what exactly, but thought I'd be a trial lawyer. Having done some internships, I saw the schedule of trial lawyers. You're at the mercy of the court. If they say jump, you jump, and those lawyers would be working 100 hours for a couple weeks and they wouldn't do anything for a while, then they'd be on again and traveling all over the country for some types of litigation. And so I ultimately decided that litigation probably wasn't for me. And my first job out of law school was in estate planning. And that's what I've done for the last decade and truly kind of love the practice area, but knew I wanted to be a lawyer. Just the type of lawyer is what sort of changed along the way.
So, how did you get to where you are now? I mean, kind of give us the story about Geoff.
Sure. So I went to Ohio State University for law school, graduated from there in the middle of a recession. And so job prospects weren't great. The way law school typically works is you have an internship at a law firm and then they hire you on and that's where you start your career. Well, I didn't know in law school, I would meet my now wife, who was not from the small town I was from, who was from Columbus. And so I was the crazy person who turned down my job offer to go back home and said, I'll see what kind of career I can find. And the only real opportunity that presented itself was at a boutique law firm that did estate planning and elder law work. And so they were starting their firm. And so we helped grow that together for a few years. They now have, I don't know, probably more than a dozen lawyers and offices all over the place. I'd always sort of dreamed of being at a full service firm. That's where I had done my internship work back in my hometown. And full service just means we have lawyers who do everything. I've got real estate lawyers and litigators. We have people who handle, family law disputes. We have estate planners like I do. We've got sort of everything. And the purpose of that is that when my clients call me, I do their estate plan, but they might need a lawyer for something else. And at the boutique, I'd have to refer them out to a divorce lawyer or a real estate lawyer or whatever. But now my clients can be served in all the various areas. And so when an opportunity presented itself, I guess 6 years ago, it's been that long, to move to my current firm, I jumped and, got into the sort of the business model I'd always looked for. Have done just the estate planning piece primarily, though, as I've worked with more and more families, a number of those people own a small business or have a side hustle. And so as my firm represents primarily closely held businesses, I've gotten more and more involved with the business aspect of things, everything from the succession planning to just day-to-day stuff. I had a client email me right before this call. She just bought out another business, and with that comes a new lease. And so she fired over her lease saying, can you take a look at this lease for me? And we can happily do that kind of stuff for her. So that's sort of how I got to where I'm at.
So you mentioned that that you primarily do estate and elder law. So can you explain what the difference is between the two?
Yeah, there really isn't much of a difference, as the people would like you to think, who have flashy websites and domain names that they claim it's some sort of unique or different area. It's the same tools. We're using powers of attorney, wills, and trusts, trying to figure out where do you want your stuff to go when you pass, with the added spin that we're now focusing primarily on retirees. And the one sort of new thing they're trying to figure out is largely, how do we deal with long-term care expenses? So, if me or my spouse needs an assisted living or a nursing home, what am I going to do? And so elder law takes the same tools. We use different types of trusts and wills and things, and figures out, how do we help you pay for that? And that could be private pay if you've got the wherewithal and the resources to do that. It might be recommending they talk with someone like you, to either invest properly or get an insurance policy to cover it. Or if options 1 and 2 aren't available, there's some legal techniques we can use to help qualify for different types of government benefits. And so I need to be well versed in areas of Veterans Affairs law, for instance. So I'm accredited with the VA because they help veterans pay for that type of care. And then Medicaid ultimately is the largest payer of nursing home type care. And so being familiar with those laws kind of makes it become elder law, but any elder law attorney could set up an estate plan. An estate planner may or may not want to dive into the Medicaid and VA work. Some of our older attorneys have said, I didn't learn this in law school. I'm not going to learn it now. You younger guys can figure it out. And so it tends to be the younger generation of people who are coming up. And that's just a product of, I mean, look around, they're building senior living facilities everywhere you look. And so someone's going to figure out a way to pay for that. And there are some legal techniques that can be used.
So you talked about setting up a trust. How would, someone setting up a trust, how would that help them, when it comes to the long-term care?
Yeah, so trust can be used for tons and tons of purposes. Sometimes we're doing it because, your kids are too young to inherit the property. Maybe, someone has special needs, they need a special type of a trust. We get into the elder law space. There's really a couple ways they can be utilized. And it's primarily based off the way the VA and Medicaid laws are written, but at a super high level, this is the 30,000 foot view for sure. You can use trust to move assets outside of your name. And if it's far enough in advance from when you need care, those assets might not be a part of what they call the spend down. So if you needed to check in the nursing home today, they'd ask, Gary, what's in your name? How much money do you have? If the answer is more than $2,000, they'd say, well, spend your own money, Gary. And when you run out, now Medicaid will step in and help you. Well, this is super simplified, but if we'd met 10 years before that day happened, and we'd say, let's move some assets out of your name, maybe some of your savings, your home, certain things, and enough time passes, in the case of Medicaid, there's a 5-year look back, then those assets that we got out of your name, we don't have to disclose them, and they're not a part of that spend down process. So there's the proactive side of things where you do that. We can also reactively, let's say you called and said, my mom's in the nursing home, she's got $100,000 left, but what do we do? Can we save any of that? There's some reactive planning you can do as well. That's very complicated for today's discussion, but just know that if your listeners are in that situation, there's planning that can be done, even if it's too late to plan proactively. And in both of those instances, we would use trusts to hold whatever it is we're getting out of your name, because we don't know what happens. You might need access to those things again in the future. And so we don't want to just give them outright to someone and expose them to liability, risk, all sorts of those types of things.
2 questions off of that. So the first one is that I've heard people talk and say, oh, well, I was told to just, my mom's got this money, just take the money and put it in my name. And then it's not my mom's name, and then she can go into the nursing home and Medicare will pay for that. You just said that there's a 5-year look back. So what happens in that type of situation if somebody were to do that?
Yeah, so a couple things. One, the gift to just the son who's going to take care of mom, there's too many risks involved there, and it might not be son's own bad doing. What happens if after you give the gift, daughter-in-law doesn't want to be daughter-in-law anymore and half your money walks away with a former spouse? What happens if, son gets in an accident and someone's suing him because, he ran a school bus off the road or something along those lines? There's too much risk to the outright gift side of things anyways. But to answer more directly your question, if a gift was made, which Medicaid calls an improper transfer, just to use the lingo, within that 5-year period, if the money's still there, you can essentially give it back and it'll be back in her hands subject to the spend down. If the money's gone, then you can be in real trouble, because Medicaid says for every dollar you give away, they're going to calculate what they call a penalty. So in rough figures, let's say you gave away that $100,000, they would divide the size of that gift by the average cost of a nursing home. Let's call it 6,000, just so the math's easy to do in our heads. They'd take your $100,000 divided by 6. They'd get, you're the finance guy, tell me the answer, 14, somewhere in that range. Right. And they'd say, even though you're out of money, grandma, for the next 14 months, because that money you gave away, we're not going to help you out. You're either going to have to move back home or find some other way to pay. After you've waited out your 14-month penalty, now you can get onto Medicaid. And so you can be in some serious trouble. And we hear stories like that all the time. And there's probably some that work, right? They give it to the kid and 10 years pass and nothing goes wrong. But the problem would be, what if the money's not there for some reason? You can get your parents in some serious trouble. And so before you give away those size of assets, you definitely got to talk with professionals. And that could be on the finance side, the legal side. Hopefully it's sort of a team conversation.
Right. And that's, I was here, with small business advisors, we're constantly preaching team and constantly, talking about making sure you have the right team and create your plan. Because the thing that we always run into is people don't plan. And if you don't plan, then it's reactionary. And as you know, most of the time, if it's just reactionary, you're making mistakes.
Absolutely. That's huge in this long-term care space. If you wait too long, you can't get insurance anymore. If you don't have that 5-year look back, you can't rely on benefits anymore. And so you got to be proactive on those things.
Right. So in going into back to the trust piece of it, lots of times, I'm going to say, mom, dad, grandma, grandpa, they don't want to do a trust because they think that they're giving up all of their rights, and that whoever they name is going to be the person they're going to have all my money and I'm not going to be able to do what I want. What do you say to that?
Yeah, so a couple things. It really depends what type of trust you're doing. In this long-term care space, you're probably going to have to give up some control. If we're not talking about long-term care, it's a trust for someone who's holding it till their kids are old enough for something. You probably retain the control to change the trust, to revoke the trust, do whatever you want with. But in this long-term care space, you probably do need to give up some control. What I'll say is that you can maintain some, let's call them purse strings, some ability to make tweaks to it. So in a lot of the documents we're doing, if we're moving money out of someone's name, we don't know with certainty what life's going to bring, and they may need access to it. So mom and dad probably can't be the beneficiary of that trust, and they're going to pick someone to be the trustee. Let's say they pick their son. Well, if the son as trustee isn't doing what they want, it's okay to retain the ability to change the trustee. So they could fire their son and put their daughter in place. And then the daughter hopefully would do what they want, and they can't name themselves, but they could keep switching this out. They can also control who inherits the money. So instead of an outright gift to you, and Gary, it's yours, you do what you want with, I could hold it in a trust that says it's held until I've died. When I die, when I write it up, Gary, you're my beneficiary, but I retain the ability to change that. I can't make myself the beneficiary, but if you've made me mad and you won't facilitate what I want, I'll cut you out of my plan and leave it to the other kids. I'll leave it all to my church or my alma mater or something like that. So you can have some threats. You can't have direct control in most of these circumstances. Otherwise, the government would say, these are still your assets. We're going to count it towards our calculation. So you are going to have to give up some control, but it's not nearly the same as if you just cut a check to your kid and hope they give it back to you someday.
So when you put these trusts together in these elder plans, how often after you put them together do you meet with your clients?
Yeah, that's a great question. And it varies a lot depending on the family situation dynamic. I have some people who something occurs and they reach out to me very routinely on these. If it's a real proactive plan, I'm 65 and we've moved some funds and who knows if I'll ever need the nursing home. Some time's going to pass. I try to make sure every client's coming in periodically, whether they're on the estate planning side or the elder law side. If I haven't seen you in 3 years, then life's probably changed enough that we ought to sit down. So I invite all clients to come back in at least that often. If I haven't heard from you in any other way, I'm going to reach out and just sit back down. And, that could be completely different. If you set a plan up and mom or dad thought they were going to be home for 5 years and someone had a fall 3 years from now, 2 years from now, you're probably going to call me and say, oh my gosh, what do we do? And so they can be pretty different, but certainly I recommend it every few years. We see way too many plans where, particularly on the estate planning side, mom and dad created a simple will back when they had their first kid. Now their kids are 25 or 30 and someone like you, their financial advisor says, what's the status of your estate plan? They said, well, we did one 30 years ago. And they say, okay, well, who's your lawyer? And it's like, well, I don't know where he or she is. They may have retired, could be dead for all I know. And so a lot of lawyers don't do a good job staying in contact with their clients. So we try to be proactive on that front. And, I don't want to get in a situation where I don't have good contact info, but I'm holding their will or something like that. And so we want to see you every few years at a minimum.
If I have a house inside this trust, is it really difficult for me to be able to sell it?
It depends how they're structured. So a lot of times we'll use what's called a life estate. That means you have the right to stay in it, occupy it. You get your discount for being owner occupied, for senior citizens discount. In some states, we have homestead taxes, and not have the asset considered yours. You probably need the sign off of the trustee to do it. Otherwise, Medicaid would say you have too much control over this house. And so you're probably going to need a trustee to be a part of the transaction when you go to sell it for that type of a trust. Some huge majority of the trusts I create aren't for elder law planning. They're just, my home that I'm sitting in right now happens to be held in my trust.
Right.
I have the full ability as my own trustee, along with my wife as co-trustee, to refinance our house, to sell our house to her once. There's no real difficulty in it being in a trust. The nature of the trust doesn't make it harder to sell the house. What might make it harder is that if we're telling Medicaid I don't have control of the asset, then you probably need a third party to be a part of that transaction. So in that limited space, there's the extra hoop of your son or daughter has to come to closing with you.
What I'm hearing you say is that there are different types of trusts depending on what you need. So you can't really just do hey, I'm going to go on to that online place and pull down a trust and create my trust and I'm done.
That's exactly right. in the last week, I've probably prepared 5 or 6 different types of trust, depending on circumstances for people. And, there are certainly dozens that are out there. There's probably some people who fit into pretty close to what our standard form looks like.
Right.
And that's okay, but you really need someone to guide you through to make sure you get the right instrument. I had a call yesterday. Someone said, this is my family situation. Here's what I need. My brother's in the same boat. Would it be possible for my brother to just kind of use your forms and swap the names out? And I said, oh gosh, no, please don't do that. I don't know enough about his, income situation, his taxes, his assets. We're not taking a plan and just, plugging a new family's name into them. What you're paying us for is the legal advice. If you're viewing us just as a repository of documents, then yeah, go get LegalZoom or something. But if you're looking for sound legal advice, that's where we come in. As you tell me your situation, and I advise and counsel you as to what might be appropriate for you. And so, particularly with trusts, I would be really worried about LegalZoom or other online vendors. There's some documents that are a little simpler. Each state has standard healthcare and financial power of attorneys. Most states do, at least. Here in Ohio, my forms are customized, but you can get a pretty good healthcare power of attorney if you just go on to one of the local hospitals' websites. And that's probably going to be pretty sufficient. Should a lawyer review it? Maybe, but that's different to me than your will or your trust. I mean, can you imagine you've worked your whole life for whatever the nest egg looks like, and you're going to try to save a couple $100 by downloading some form? I guarantee you're going to cost your family more because you've not executed it right, or you've done something wrong, or you don't fund it. Something's going to happen that the couple $100 you saved is not going to end up being best for your family.
Yeah, you just hit big nail on the head there when you talked about it's like, people try to save a couple dollars, and in the long run, it costs so much more, on the backside, in taxes or just aggravation or whatever. I'm constantly preaching to business owners, as they're going into a business partnership with somebody, you need to make sure that you have your, operating agreement or bylaws or partnership agreement, whatever it is, and you need to have that ironed out before you guys start doing this, because everything's great now. But then when it's not good, it's not good. Same thing with families. When someone dies, it's like everybody's happy and everything else until money's involved. And then it kind of gets a little bit ugly.
I mean, we see it a ton on both sides. On the business side, you're exactly right. If you're the sole person and it's a single member LLC, could you get by without an operating agreement? Probably. You get the default laws from your state, which are probably somewhat reasonable. But as soon as you have that partner, it is completely different. In Ohio, I just had this conversation yesterday with one of my business colleagues and a couple of prospective clients. In Ohio, you and I go into business together. We each contribute $50. We are 50-50 owners. If later today we have an expense and I contribute $25 to it, my share of the company goes up pro rata by what we put in. So now all of a sudden I'm the 60-40 owner and you're not in majority control anymore. That's probably not how you want your business to work.
Exactly.
So if you do an operating agreement, we can say what happens for reimbursement of expenses, those kinds of things. And so absolutely, that's important. Same thing on the family side. Anytime we're administering an estate where there's no will in place because they didn't want to see a lawyer or didn't want to talk about death or whatever, I can almost guarantee that. And with near certainty, almost every time we come across one, those end up costing more than if we'd have had even a simple will outlining who's in charge, what do you do with the assets. And some of the problem is that a will says things like, my executor can sell my house and my car, and they can dispose of my stocks, and they can pay my taxes. Well, no will, you didn't tell us that. So the court says, well, you must have wanted the court to sign off. So now the court has to approve the sale of the house and the car, and your lawyer is going back and forth to court a bunch of times. That gets expensive. So absolutely. A little bit of planning and payment on the front end helps a lot. And that's true in a lot of areas. I mean, in your line of work, with taxes, with any number of things, getting out in front of it's easier than fixing the mess.
Oh, yeah. Yeah. Unfortunately, many people wait and come to us after they have the mess, and then we have to fix it.
I got this huge taxable distribution this year. It's already in my hands. What am I supposed to do with it?
Right. And that's one of the reasons why, I've been doing this podcast and bringing people like you on it, to be able to let people, really know. It's like, look, you really need to do the planning and think about this.
Makes complete sense.
Lots of times we hear people talk about asset protection. And many times people think that has to do with, my assets are diversified. But truly, what does it mean when somebody talks about, asset protection and planning for, elders?
Yeah, that's another one of those buzzwords you see a lot. And it can mean a couple of different things depending on the circumstances. In some regards, asset protection gets used largely in the elder law space to talk about that long-term care planning. I know, there's a number of folks who kind of use that as asset protection planning. To me, it's a little broader. I have clients who we do asset protection for a number of reasons. What you're trying to do is make sure that there's not some liability out there that can pierce what it is you've worked for. So, in the business context, if you're engaged in a risky profession, you wouldn't want your liability to cause you to lose your investment and savings and those types of things. So we're protecting your assets. A lot of times we use limited liability companies and trusts to do that. Right. Asset protection in the elder law space typically means we're trying to get as much of your nest egg to your kids or charity or wherever you're hoping to leave it. And how do we do that? Well, you're trying to solve that long-term care problem. Two, the other big one's taxes. Is there some estate or capital gains tax problem that we can solve so that more of your assets get to your kids? And then, certainly probate can be a big cost. Depending on what state you're in, using a will and going through the court system can be really involved or complicated. Yeah. Ohio has a very supervised probate process. And so that it tends to be more expensive to administer an estate than a trust here in Ohio. I've dealt with some states where the probate court's not a big deal. We have a lawyer who's licensed in Illinois. So I helped with an Illinois estate not that long ago. And in Illinois, if your family all signs off and says this all looks above board, it's all kosher, well, then the court says that's fine by us. We don't need to see any details. Well, here in Ohio, they need the details. So probate can take away a huge chunk of your estate because the court wants to see down to the canceled checks in some counties, what assets came in, what did you spend the money on, and you have to balance it down to the very cent. Even if the family agrees, the court still has to sign off. So in the elder law space, those are the big three: the probate, taxes, and long-term care. But asset protection generally is broader than that. If you have a rental property, I don't want your tenant to get hurt and sue you and you lose your investment account. And so I'm going to isolate your rental property into a company. And if you consult on the side, in addition to your main job, I wouldn't want bad advice you gave to cost you to lose that rental property. And so we kind of try to bucket into little things surrounding any risk with some layer of protection. And it isn't all legal work either. Asset protection might mean go get proper insurance, whether that's for your business, an umbrella policy, et cetera. And I don't sell any type of insurance, but it's a really good extra layer of defense that if something goes wrong, you've got, a company willing to back you so that you don't lose those assets. But that's sort of the concept at a high level.
So, who's an ideal client for you?
Yeah, there's a couple of real kind of broad general buckets for me, and then the firm's a slightly different answer. So I'll give you sort of three answers to that, if that's all right. So on the younger side, I have a young family myself. I have a lot of people who are similarly situated to me who married, starting a family, a couple of young kids who need to get sort of their first plan in place that if mom and dad pass too young, who raises the kids? Right. How old should the kids be when they inherit? We probably don't want them to get at age 18. So we hold it till they're out of college, let's hope, maybe married, maybe into a career. So I have a lot of those. I also have a lot of people who someone like you identifies, you did an initial plan 20 years ago and now it's sort of gotten out of date. Let's plan more for retirement. So I have a lot of people who are nearing right around that sort of retirement age that their kids are probably grown. They don't need guardians named for them anymore, but they're probably going to now name their kids to serve as their power of attorney, as their executor, as their trustee, et cetera. And so I see a lot of folks in that age. They may or may not be worried about the elder law concerns. Some of those folks have, the resources to pay for that type of care. Some of them have bought insurance policies. So I might not be talking elder law to that group, but that's sort of the second big group I see. Okay. And then as a firm being full service, we represent a lot of closely held businesses. And so the ideal firm client would be someone who owns a business who could utilize us when they have, an employment problem with an employee, the lease I mentioned earlier that we're reviewing, when you're buying a building. My first call this morning was a piece of litigation that a client's involved in. And so, those clients can utilize 5 or 6 different types of services we can provide. So as a firm, the answer would be business owners. For me individually, I don't know, the majority, 9 out of 10 of my clients just work for a company somewhere and don't own a business, and that's perfectly fine. Happy to work with those folks too.
Right. So what are the first steps if somebody wants to talk to you to find out what they need to do and move forward? What do they need to do?
Yeah. So if they're completely ready to go, drop me a line, shoot me an email. I generally try to give an initial consultation without a consultation fee, so people aren't scared off that they're paying just to get to the table. And so I would send out an intake form that would give me the details, who are you, spouse, kids, gets your balance sheets. They bring that to the first meeting, and I'm using the word meeting loosely. We're doing a lot of stuff virtually, of course. Right. But you typically bring that to the first meeting. We'd review that together. And the goal would be after we've sat down for, an hour or so, I can identify, here's what you have and it's great, congratulations, or maybe here's what you're missing and what I propose for you to consider. If people aren't quite that ready, there's a lot of great information on our website. Our intake form's even there, so you can see what it would look like. And so just at cpmlaw.com, we have our insights page. We write, monthly newsletters on estate planning and business and litigation. And there's a ton of info out there that if you were not quite ready to call the lawyer yet, but to learn about, whether it's estate planning, business law, elder law, et cetera, you could get a lot of good info from our website.
Right. So the so for that first meeting, you typically want them to have the intake form filled out and back up with it, just to be able to sit down and talk through it.
It's preferred. It just keeps it more efficient rather than spending the first 20 minutes asking you your full name and address and your date of birth, and then go do that with your wife and then each of your kids. And then finally, 20 minutes later, we've gotten into the meat of the conversation. We can bypass a lot of that. Additionally, my penmanship's horrible. If I'm the one jotting these details down, there's a high likelihood there's either going to be a number transposed or I'm not going to be able to read a letter. And so if you give me the data, it's more likely to get to, my assistant intact than if I'm the one keeping the notes. And so selfishly, it helps in that regard too. And then, if you come to the meeting with a balance sheet prepared, you're probably going to get most of the items on it. The number of times where people don't take that step, and then we're in the meeting and, oh, wait, don't we have an account over at that one place, or what's that annuity thing we had that one time? And so the exercise of writing down in the family and your balance sheet and bringing your past documents often brings them to the meeting a lot more prepared than they otherwise would be, but it's not an absolute requirement. I have one where someone was referred to me just yesterday and said, can we meet Monday? And I said, sure, here's my intake form. He said, well, do I have to do this before Monday? I said, well, no, I need it at some point, but if there's urgency to this, let's have the conversation and see if we're a good fit on Monday.
I know that we have a client questionnaire that we always ask people to fill out. I mean, because again, it's going to give us the basic information about them. And when we don't have that, it does. I'm the same way. It takes so much longer, kind of in that initial meeting, trying to get this data from them to be able to then talk. So yeah, I think with anybody who's listening to this really needs to understand, it's like doing a little bit of homework ahead of time is really going to make more useful time when you're with the professional that you want, especially when you're looking at it, hey, you're giving them that first hour for free because you're talking about stuff. So make good use of it.
Yep, I completely agree. And even if we didn't move forward, just the exercise of putting together a current balance sheet is a useful tool to have saved somewhere in your household. If something happens to you, your kids are going to have a starting point. And so now if they're working with you probably have one prepared for them. You can just email it over to me. So that's easy. But if they're more of a do-it-yourselfer, then that exercise is helpful, even if you don't end up putting a plan together with me.
Right. So what would you like to share with our listeners that I haven't already asked you?
Great question. I mean, we've covered a lot. So we talked about most of my practice areas. I would just say that, and I said this on something else recently, but if you think you might need a lawyer for something, you probably do. Don't be afraid to call us. People are always worried about, what about the hourly rate? If I call you, I'm going to get a bill for it. Much of what I do, we do on a flat fee nowadays. I'm always willing to have that first phone call or conversation. And so it's going to be beneficial to bring us in on whatever the dispute is, probably earlier than you think it's necessary. The number of times someone has come to us that, hey, we entered this contract and we were, now it's going sideways. What do we do? And it's like, well, you shouldn't have had these terms in the agreement. We're stuck by them now. I mean, I'm helping someone with a cease and desist letter earlier this week where had we had a certain provision in it, we would have had a stronger position now, but we weren't involved from the start. And so I'd say, don't be afraid to call, and certainly in certain areas, use professionals. I mean, get properly licensed financial advice, go to an accountant for your taxes, go to a doctor. You're not going to go to WebMD and try to fix, your broken limb or disease or whatever it is you got. So same thing, like don't be on LegalZoom, don't be Googling tax advice, hire a proper financial advisor. I mean, all that, there's certain areas we just need a professional. They talked about the robo-advisor replacing your industry. I don't think that's happening anytime soon. I mean, you've got, so many valuable insights to lend to people, particularly business owners. And so I think involving professionals is always a good idea from the outset.
Well, we really appreciate your time today, and great words of wisdom that you've given us.
Absolutely. Happy to be here and share it. If I could be of any help in another way, happy to, take a call or send an email out. So just want to be a resource for you and your clients and listeners. And it was a pleasure talking with you.
Thank you. So Today, our guest was Geoff Kunkler with Carlile Patchen and Murphy LLP. Thank you.
This show has been produced by Market Domination LLC. To discover how you can have your own show completely done for you and turn it into a real published book and become the authority in your marketplace, go to www.marketdominationllc.com/podcast offer.